have gone through Sayn-Wittgenstein and Sayn, Borbon and Borbon.
Yes, Mr. Rossi.
Good afternoon, my lord. I appear for the applicant with my learned friend Mr. Luckhurst, and Mr. Lewis, Queen's Counsel, appears for the respondent on my application for permission to appeal.
Will you excuse me?
Yes.
There's a matter I wanted to mention to my lord
Of course.
before we came in, and I forgot to do so. Perhaps we'll just step outside for a minute. I'm sorry, that's not very efficient of me. Yes, I'm sorry about that false start. Yes, well, one housekeeping matter, which is that I seem to have left my authorities behind, but my clerk has gone to get them, so I hope that'll be all right.
We've got an extra set, my lord. If
Oh, well, that's very
pass
convenient.
that.
I think some of mine will be marked up. But the other thing was this. The provisional view of both of the members of the court is that it is arguable that paragraphs 15 to 22 of the particulars of claim allege acts done by the defendant prior to his abdication, which were done in his public capacity within the meaning of section 14, and that the amendments which the judge permitted did not necessarily change the position about that. What we're accordingly minded to do is to hear Mr. Lewis first on those aspects, where it's effectively grounds 1, 2, and 4. When I say first, I don't mean now, but after we've heard you on the remaining grounds.
Yes, my lord.
And then we will, of course, hear from you if he makes headway in
Of course, my lord.
changing our provisional view. I should perhaps just say for clarity that it doesn't follow from what we said that we think every point advanced under each of those grounds may be arguable, but we don't think it's worthwhile exercise at this stage to try and separate any chaff from wheat. We take effectively grounds 1, 2, and 4 together. So, at this stage, you need only address us on ground 3 and I suppose ground 5. You will need to leave time within the 1.5 hour estimate for Mr. Lewis to address us on the other grounds, and for you to come back if necessary.
Of course, my lord. Thank you very much indeed.
But one more just footnote to that. Of course, in a sense, Mr. Lewis is lucky to have any chance at all, because normally he'd be confined to his written submissions. Mr. Lewis, we will expect fairly brief and focused submissions, or even more brief and focused than Mr. Otti's are going to be. But you will certainly have your chance to change our provisional view about that. Right.
My lord, thank you.
Ground 3.
Ground 3, my lord, and just if I could mention at the outset the one other matter of housekeeping that your lordship was kind enough to write to us about last week.
Yes.
And the question of our supplementary skeleton. We took fully on board your lordship's observations about the question of costs, in particular in relation to that.
Yes.
And subject to the court's view, at least, I'm happy to say the parties are agreed as to the way forward. We have proposed that my client pay his costs of the supplementary skeleton argument in any event. We have proposed that he pay an agreed sum identified by the respondent for preparing her written response in the form of the note that the court has seen. And then that, so far as the respondent's other costs are concerned, they will of course be costs in the appeal or costs in the application, according to the final.
If that's agreed, I'm quite sure the court won't want to unsettle it. I'm sorry, I'm in an odd position. I've been prepared for this a week ago. I was very engaged with the issue of the supplementary skeleton, and from my point of view, I rather moved on. It was not very satisfactory, the course that was adopted. That's a polite way of putting it. But we are where we are.
We are where we are, my lord, and we I hope, responded appropriately in addressing the question of costs, at least in relation.
Yes, but really, we should now move on to substance.
We'll move on.
Thank you for dealing with that.
Thank you, Mark.
I mean, I didn't make a note of that, but that will come up to the court at some point, will it?
My lord, then ground 3
yes.
And the question of household. So far as that is concerned, my lord, we say that at least arguably, to a non-fanciful standard, the judge was wrong to conclude that the apex decision in the Court of Appeal was indistinguishable. Alternatively, we say we have at least an arguable basis for contending that the apex decision in the Court of Appeal was wrong, such that the course contemplated by the editors of the White Book would be appropriate, namely the grant of permission with the appeal dismissed, so as to allow the points to be tested in the Supreme Court if we get that far.
Yes, I see that's how you put it. I think I speak also for my lord in saying that probably your main focus needs to be not so much on that part of the judge's reasoning, which I think is paragraph 61 to 63.
It is, my lord.
But more on para 64, because even if there are arguable points about whether apex was distinguishable or even whether it's rightly decided, they don't get you anywhere if on the facts of this case, the judge, sorry, the defendant cannot on any view be said to be part of the household of the present king.
I see that, my lord.
So that's really, I think, what we would most appreciate being addressed about.
Certainly, my lord. I'll give my summary response, if I may, and then develop the submission in a little more detail so that I don't lose something in the structure. The summary response is this. If the test contemplated by Sir Arthur Watts in his lecture, which the court has seen featured in the judgment of Mr. Justice Voss at first instance, and in the Court of Appeal in Apex, is the correct test, then we have at least an arguable case that we are within it.
Yes, you'll take us to that in a minute.
I'll take you to that in a minute,
Yeah.
But in essence, it is a factual question to be decided in every case, and the meaning of household depends on the extent of close ties and special circumstances applying in the individual case. And that formulation of close ties and special circumstances is not plucked from the air, but is taken from the Travaux to the Vienna Convention on Diplomatic Relations, and so would be a classic tool for interpretation of that convention, which is ultimately what we're concerned with here for the purposes of Section 20, because as your lordships have seen, Section 20 brings in the protections of the Vienna Convention on Diplomatic Relations to members of the household. So I'll come to that, my lord. But that's why we say the judge was wrong to say we would in any event fail. And with respect, Mr. Lewis is also wrong to say we would in any event fail. Because Sir Arthur's test is more nuanced than either the judgment or Mr. Lewis's argument appreciates or acknowledges. As my lord has, going back to the full run of submissions, if I may, and I'll take them briefly.
Yes, at some point we'll want to know exactly what we say the close ties and special circumstances are that you rely on, but you're coming to that.
Well, I'll come to, again, my lord, to preview without, I hope, spoiling the feast when we get to it, but there's no difficulty, we say, at all here because we're in very unusual territory. We're not just dealing with an elderly parent who was the king. We're dealing critically with a closed class of only 6 individuals forming part of the royal family or royal house as defined as a matter of Spanish law. And that is a critical factor which shows a hard-edged test in this case for the application of close ties and special circumstances. So there's no difficulty of the kind that Lord Justice Briggs anticipated in Apex as to where one might draw the line. And there's a very obvious distinction with the factual position being contended for in Apex, where there was this class of up to 5,000 princes who might, on the test being contended for by the 2 princes before the court, be within the household. So there's no difficulty at all, my lord. And again, without anticipating too much, your lordships will have seen another feature of this test of household is the concept of dependency. And as we see from Apex in the Court of Appeal, the reason that dependency matters is significant. The reason dependency matters in the view of the Court of Appeal in Apex is that to bring proceedings against that other group of family members would inevitably impact on the discharge of the regal function. And it's not remotely difficult, we say, at least for the purposes of a permission hearing, to say that to allow proceedings to be brought against an elderly parent who forms part of the legally defined and closed class of members of the royal family would inevitably impact on the discharge of the regal functions of the current sovereign.
How?
Because of the, well, it flows from the close ties and special circumstances, my lord, because of the impact upon the dignity, because of the distraction inevitably caused. And again, I'll go to it, but again, we draw support in that regard from the different case decided in this jurisdiction by the President of the Family Division in relation to the Duke of Edinburgh's will, emphasising how the particular legal consequences applicable to that will, and whether or not it should be published, could impact upon the dignity of the sovereign herself.
Where is the evidence of impact on the regal function?
It's inference, my lord. There is not evidence of that, and we say it follows inevitably, again, at least to the level of arguability, from the closed small class. It would be impossible for me to...
It would be simplicity itself if that evidence was available to provide it.
My lord, there is no evidence of that kind before the court. I'm addressing the court on the correct test. Whether we get there in the end, in satisfying that test, is of course a critical...
You were dealing with the issue of dependency and impact.
Yes, my lord.
I was only asking, in a sense, to be shown where the high point of the evidence was about that.
Well, my lord, for today's purposes, I don't have any more than the closed class. And we say it flows sufficiently for my purposes from the closed class.
So dependency and impact, you're mentioning it, but you don't have it.
I don't rely upon the test of dependency, my lord. I rely upon the rationale for that being a criteria, namely impact on function.
Well, we've got small group, closed class.
Small, and just as, my lord, just as would be the case if we were dealing with a child or other agreed dependent member of the family, we say it inevitably follows, once you've got this closed class, that there is an impact on function. Now we'll go to the extent itself, we'll go to the President of the Family Division's judgment on that. But I've jumped ahead quite a bit.
No, well, it's always helpful to see where you're going. But
thank you.
We will try and keep quiet for a bit and let you develop those points.
Thank you, my lord. So, my lord has rightly identified the paragraphs, of course, 61 to 64 of the judge's judgment. The judge's primary reasoning is that in paragraph 63, because it's there that he says he was bound by the decision of Apex in the Court of Appeal to conclude that the applicant is not part of the King's household.
Well, that's true, but where does it get you? If a judge says, my primary reasoning is this, but in the alternative, I in any event find that.
Oh, no.
That is good enough, isn't it?
It is, my lord.
Yes.
But it might well be the case in a context as anxious as this. And your lordships have seen the observations of Lord Lloyd Jones in the General Dynamics case about the particular sensitivity of sovereign immunity and equality between states. It might still be the case that the court would say, and I would certainly invite the court to say, well, we're giving permission, subject to Mr. Lewis's submissions, we're giving permission on 3 grounds. There is a compelling reason now also to clarify the test for household immunity too, even if we're very sceptical as to whether, or even if we're of the view that this applicant cannot meet it. I entirely accept I have to deal with both limbs of the judge's reasoning, but I say I get a pretty fair wind in my sails if I get over paragraph 63 and show that there's a prospect of displacing apex, either because it's distinguishable or arguably wrong.
Okay.
Now, so far, and I'll deal with it, if I may, in that order for that reason. Now, at paragraph 63 of his judgment, the judge accepted, as he put it, that fundamentally the assessment of household is a factual one. But it was an assessment that had to be conducted in accordance with the principles identified in Apex. And he held that in Apex, the Court of Appeal decided that the key factor required for an individual to fall within a sovereign's household was a relationship of dependency. And that the applicant, was not dependent on the king. And he also considered in that paragraph that it was relevant that His Majesty the applicant did not live with the king and did not live in Spain. And as my lord has said, the judge went on to hold at paragraph 64 that even if he had not been bound by Apex, he would still have rejected the applicant's arguments. And in that regard, the judge held that membership of the family of the king could not be sufficient by itself, and that the honorary status conferred on the applicant by the Constitution, allowing him to carry on using the title king, could not alter that conclusion, having regard to the fact that the applicant had retired from public life and no longer discharged any public functions. Now, we respectfully submit that the judge was wrong to find that the reasoning in Apex required dismissal of his argument, and he was wrong to place weight on the fact that he doesn't live with the king. Alternatively, as I say, we submit that Apex Global was itself at least arguably wrong. And I'll address each of those submissions in turn and then deal with paragraph 64. But before doing so, I just want to emphasise again the 3 aspects of the factual position as it applies to the applicant. First, as I've already said and emphasised, he is one of only 6 members of what Spanish law describes as the royal family within the royal house, or the house of His Majesty the King.
Can we just deal with that point? There's nothing in that point about it being called the royal house. That's just an idiosyncracy of the labelling in Spanish constitutional law.
No.
It's not. In fact, I think the same evidence says the royal house is different from the royal household in Spanish law. So I think if you weren't, but if you were trying to make any point on royal house, it doesn't get very far with me.
No, it's the closed class that matters, my lord. And I was simply seeking. I'm not saying that there is a Spanish law provision which uses the concept of household in a way that assists me. But what I am saying is it's the closed class that matters, whether you call it the royal family, whether you call it the royal house. Because that tells you who has particularly close ties, and that tells you something, we say, about the importance of that closed class to the serving sovereign and the discharge of that serving sovereign's functions. Now, I take entirely my Lord Justice Jackson's point that may not be enough at a full appeal to prevail. But I say it's a sufficient arguable basis upon which I can rely.
Well, hang on. You say that the fact that there is a defined royal family, core royal family, let's call it that, of 6 members, basically the king and his consort, his parents, and their 2 children, is a sign that all members of that class assist in the royal functions.
No, my lord. And this is an important
Oh, I
distinction.
see.
This is
I
why I
understand your
emphasised at the outset, and I'll go to it in detail, Sir Arthur Watts' test is a broader one than contended for by the princes in Apex. It is not simply to say only individuals assisting in the discharge of royal function will be within the household.
Yeah, okay, but you did mention the discharge of royal functions.
I did, my lord, and that was what was in play in Apex. The princes were saying, Prince Michal, I think in particular, was saying, I assist in the discharge of royal functions. Sir Arthur, in his lecture, identifies that as a possible basis for someone being within a royal household. Therefore, I'm within the royal household. But if you go back to what Sir Arthur's actual test is, it's a question to be answered on the particular facts of an individual case.
Okay, and you were wanting to re-emphasise the three key points. One was the closed class point. Yes?
Yes.
What was the other two?
The second was that it was this concept, which I think I've sought to explain anyway, which we say has particular relevance to the question of English law, who is a family member forming part of the household. And the third point, my lord, and it's an important point, we say, in terms of the...
Do you want to, sorry, before you leave that, because I do want to make sure I've understood
Of course, my lord.
the submission. Could you present the second argument in a different way so that...
Yes, you said this concept. I, like my lord, only I was too coy to intervene. I wasn't quite sure what concept you were referring to.
This concept of a closed class of six.
So it's the same...
Maybe it should be collapsed
in a
into
different
2 points, my lord.
Right.
I don't want to overdo it. That concept of membership of a closed class, we say, is highly relevant to the question of who satisfies the English law test. The third point, my lords, is this. The potential significance of this fact, membership of the closed class of six, features nowhere in paragraphs 61 to 64 of the judge's judgment, despite it being central to the way the applicant's case was put. Instead, as the court has seen, the language used in these paragraphs treated His Majesty as no different and in no different a position to every other member of the King's wider family, however drawn. And that was one of the key factors which led the judge to decide that that submission must be wrong. But it can't be sufficient, we say, in a case of this importance, simply to omit reference to that critical component. Now, my lords, against that...
Excuse me. I appreciate what you say about 61 to 66, but 34?
No, my lord, 34 is... Yeah, I'm not saying, my lord, that the judge was unaware of the submission.
We read the judgment as a whole, and it's apparent from 34, unless there's any criticism to be made of it, that the judge has squarely recorded the submission that you say he should have accepted.
I agree, madam, and I make that point. As I said a moment ago, this was a central part of the defendant's case, and paragraph 34 is under the heading Defendant's Submissions on the previous page.
Yes.
But what I'm doing is looking at the judge's reasoning on this point. And it's no answer, we say, when dealing with the judge's reasoning in paragraph 61 to 64, under the subheading Decision, to say, well, the judge may not have referred to your central argument in those paragraphs, but he was clearly aware of it. We respectfully submit that it may well be he would have had cogent reasons for rejecting it, and Mr. Lewis would have an opportunity to say that before the Court of Appeal at a full hearing through deployment of a respondent's notice. But if
Well, I
we're
wonder
looking
whether
at
that wasn't what he was referring to at the top of the page, page 73 of the bundle. where he says, being simply a member of the king's family, but that means being the king's father cannot be sufficient, as otherwise the reference to household would be redundant. And the position occupied by him under the constitution is entirely honorary, respecting his position as the former king and father of the current king. Isn't that, admittedly rather elusively, addressing Sir Daniel's point?
No, my lord, for two reasons. Firstly, it's family with a small f. Now, that sounds a silly point.
No, I understand what you're making the point.
It's family as a small f, not membership of the royal family as defined. Secondly, it's not the constitution which defines this closed class. It's a decree. So it's not constitution.
Yeah, I have the point.
So, again, we respectfully submit that if confronted with a judgment which doesn't address a central argument, that again is a promising start to an application for permission to appeal. As I say, it may well not prevail ultimately, but it's a start. So, my lord, against that background, obviously apex is critical to all of this, and I'll go to that now if I may.
Yes.
I don't know whether my lord's bundle has...
They had.
Great. So apex is at tab 10, page 347. And I should say, my lords, we have copies of Mr. Justice Voss's judgment as well, if the court would like to see it. And I'll mention two aspects of that judgment.
We'd like to see it if you want to refer us to it. But
well, thank you, my lord.
You're in your hands by that.
Thank you, my lord. So apex. As I've said, and as the court will have seen, this case concerned an attempt by two Saudi princes, the nephew, or a nephew and half-brother.
We have read Apex, so you can introduce it.
I'm grateful, my lord. You'll see then, I'll go through the judgment quickly in that case, if I may. You'll see paragraph 2 for the summary of the issue and the recognition by the court that the interpretation of household raised an important question which had not been addressed in any previous authority. Paragraphs 15 to 18 set out the court's observations on principles about and the purpose of state immunity as afforded to heads of state and family members of the household, with an emphasis, Lord Justice Briggs' emphasis, on that purpose being, as the court put it at paragraph 18, for the protection of the performance of the head of state's regal functions, a matter Lord Justice Briggs described as being of cardinal importance to what he called the household issue. And the court then turned directly to the household issue at paragraph 19 and following. 19, we've got an extract from one of the leading textbooks in this area, Denza, describing principles going back to the 17th century and the views of earlier writers, with an emphasis at the end of 19 on protection for family members being justified because necessary to ensure the diplomat's independence, and a view that only close members of the family living in the diplomat's household were covered. At 20, we have the approach of the International Law Commission and the Vienna Convention on Diplomatic Relations summarised, with a reference to close members of the family, but an inability to arrive at a more specific definition on the part of the International Law Commission. At 21 to 23, there is a summary of state practice, varying to some extent and allowing for ad hoc treatment of unusual cases. And at 23, Lord Justice Briggs concluded by saying that a common theme of the formulations was that the central criterion for the extension of personal immunity, apart from spouses, was dependence, rather than the performance by such persons of diplomatic duties or functions on the diplomat's behalf. So just pausing there, my lords, there is an acknowledgement at least that while the central criterion is dependency, it's not the sole criterion, because non-dependent spouses would still be treated as within the household and entitled to immunity. Now at 24, we have the court commenting, Lord Justice Briggs commenting, that there's no hint in the wording of section 20 to suggest that the functional basis for head of state or diplomatic immunity was intended to be any different as between diplomats and heads of state. At 25 and 26, Lord Justice Briggs refers to internal, and I emphasise internal, UK Borders Authority's guidance in the form of the 2012 Immigration Directorate's instructions. And he treated that guidance as providing what he called a compelling and direct indication that the UK government intended no wider meaning than using the phrase members of the family forming part of the household for heads of state than for diplomats. Now,
Where is that? Were you quoting from then?
26, my lord,
Which
25
part?
and 26.
I can't find it.
It's the last 4 lines of 26.
Yes, I see.
So 2 points, my lord, just pausing there. First, in its correspondence with the court, with Mr. Justice Voss in Apex, and in responding to the question whether the princes were within the King's household, Her Majesty's government had drawn particular attention to the lecture from Sir Arthur Watts that we'll come to in a moment. And it had made no suggestion that the immigration guidance itself set out a position which attracted the one voice principle. And that's made clear in the first instance judgment, where we have that full correspondence set out in full. Secondly, just looking at the guidance, the immigration guidance itself, that internal guidance, at least on one reading, it was on its face non-exhaustive. It did not say only the following may be considered as members of the household. Now, going back to the judgment and Sir Arthur Watts, we see the court's reference to him beginning at paragraph 27.
Can I just try something out on you?
Yes, ma'am.
I obviously see what Justice Briggs said about the statute using the same language for heads of state as for diplomats. But the circumstances are very different. A diplomat is, apart from periods of leave, in the state to which he is accredited, from his point of view, a foreign state, and it is very important that he, and for the reasons given, his household have immunity, because otherwise he can be got at. The position of a sovereign is different. Will occasionally pay a state visit to another country, but typically they, and even more their household, will not be living in a particular, in a foreign country. They will be living in the country of the sovereign.
My lord, yes. So
that's an important difference in looking at the kind of protection you might expect them to need or want, isn't it?
it is, my lord, but it goes both ways. And I say, again, to the standard required for today, it at least arguably goes in my favour. And one area where we respectfully submit, at least focusing on this individual passage in Apex in isolation, one could fairly criticise it, would be to say that it suggests that there's a simple exercise of transposition going on. What's the immunity for the diplomat? Right, it's that. Therefore, it must be the same for the head of state. Well, that's not what the Act itself says. Because as my lord knows, from section 20 itself, we see that there is the critical proviso in section 21, subject to the provisions of this section and to any necessary modifications. Now, that question of necessary modifications allows for the nuanced exercise my lord has contemplated, and in some instances it might indicate one outcome on immunity for a sovereign, perhaps a narrower one than a diplomat, but in some instances it might indicate a wider view of immunity for a sovereign than for a diplomat. And what's important for present purposes and for the purposes of my submissions today is echoing really the point I was making a moment ago in relation to the question of the closed class in the Royal House. Reliance upon the necessary modifications proviso was again a central element of Sir Daniel's arguments below, and it features nowhere in the judge's judgment. And that's important for the purposes, amongst others, of distinguishing Apex, because what happened in Apex was a different modification or proposal in relation to the sovereign's immunity or the household's immunity, was rejected. And Lord Justice Briggs, as we'll see in a moment, rejected the Prince's submission that the concept of household should be modified in their favour through this proviso to the destination they sought to arrive at there. But that doesn't mean that the proviso can't come to the aid of this applicant here. All Lord Justice Briggs was saying was the immunity you're contending for, the test you're contending for here, can't be reached through the proviso. But we're contending for a different modification.
Sorry, I distracted you with my question. You were talking us through
So taking
Apex, we'd broken off at paragraph 26.
Yes, no, I was just going to paragraph 27 and 28, where Lord Sir Arthur Watts is referred to, and he's rightly described with respect as offering an opinion of the utmost distinction at the beginning of paragraph 27. And the particular scope for household that Sir Arthur contended for in his lectures and writings is then summarised in paragraph 28. And you see there Sir Arthur describing household as an essentially factual question to be determined on all the circumstances in any given case. And he contemplates, in this passage that's cited here, he contemplates the possibility that there was a different meaning for household when considering a sovereign as opposed to a diplomat, suggesting that in the former there might be no requirement for dependence, and raising the possibility that the household of a sovereign could at least extend to adult members of the royal family living separately to the sovereign, but sharing in the exercise of certain royal and representational functions. Now again, just pausing there, and it's a point I've sought to emphasise already in my submissions, the actual test being proposed by Sir Arthur was to say that whether an individual was within the household was an essentially factual question to be determined by reference to all the circumstances of any particular case. And then he was
giving...
There
must be some central concept or purpose according to which that question could be judged.
My lord, yes. And the concept or purpose that we have, and I appreciate that they themselves beg questions to some extent, but when we look at the Travo, which I'll go to the Travo in a moment, or at least the citations of the Travo that were before the judge below, we have the concept of close ties and special circumstances. We have the recognition that the concept of that the term household is a concept, not a place. And we have reference in the Travo to the fact that the Spanish, at least, were contending that the concept of household should extend to ascendant.
Yes, we'll come to those in a moment, to the Travo, but there's nothing in... Sir Arthur does indeed make the point about it being a factual criterion.
Yes.
Or depending on factual criteria, factual assessment, shall we say. But if we actually then look at his discussion, which is essentially directed to the question of, which I raised with you, of the different circumstances of a diplomat and a sovereign, and in particular to the question of a member of the household living apart.
Oh, yes.
He says, well, that may not matter if they share in and assist with the exercise of constitutional and representational functions. But your problem in this case is that the defendant does neither. He doesn't live with the current king, nor has he since 2019 assisted with any constitutional representational functions. So Arthur doesn't take you very far.
Well, it does, my lord, if I'm right, that what Sir Arthur is doing in this passage is saying, my test is, this is a factual question to be decided in the individual circumstances of any case. And if the second passage that your lordship, with great respect, perfectly understandably puts to me, the second passage is an example, a non-exhaustive example of a different outcome being arrived at in the case of a sovereign as opposed to a diplomat.
Okay.
Because as my lord says, I'm not contending for a material discharge of functions by my client after 2019.
Yes. Are you going on with the judgment or going to the Travo?
I was going to go on with the judgment.
Yes, no, please do.
What I'm not at the moment understanding is how, if one was to apply the Sir Arthur Watts test to this case, it would benefit you.
Depends what one means.
Even if that was the preferable approach, as you would want to argue if you had standing to challenge Apex. How does it help you?
If by my lord, if by the shorthand, the Sir Arthur Watts test,
Yes.
my lord means
All the circumstances.
So if it's as broad as that, my
Yes.
lord,
How does that help?
it helps me because in the particular context of this case, I've got this very unusual feature.
Right. So you're back to the closed
Back to my
group.
legally defined
Right.
closed.
So you say that if one was using that as a test, then your closed group puts you in a household.
Yes.
Right. That's what it comes to.
It's what it comes to, my lord, and it's not as black letter as that, because one also then asks the question, well, what's the point of a closed class? What's the point of a narrow class defining the royal house, the royal family? We say it is the recognition that anything that happens to those other 5 people inevitably impacts upon the sovereign himself. As a matter of objective, common sense analysis, just as anything that impacts upon publication or anything to do with publication of the will of His Royal Highness the Duke of Edinburgh inevitably impacts upon the dignity of our sovereign.
Well, suppose towards the end of his life, he had to twiddle with the facts slightly. The Duke of Windsor had the law of France was identical to the English law. And he became involved in some civil litigation in France as a defendant in civil litigation. Are you saying that because he was, true, we don't have the exact same definition of the royal family, but he was in the exact equivalent position as regards George VI, that he would have been able to claim immunity? Because anything that happens to the abdicated former monarch, the father of the current monarch, necessarily impacts on, whatever you say it impacts on, the exercise of functions by the current monarch. Seems a bit surprising.
Well, I don't need to put it as widely as that. My lord has the point that we are in a territory where we've got a defined class.
Well, but I thought that this is you're saying yourself, this is an international law concept.
Yes.
So the fact that in Spain they happen to have a definition of the core royal family, 6 people, it doesn't really help.
Well, it gives, we say, a clear insight into who does or doesn't have the close ties and special circumstances.
Well, it's accidental in a way, isn't it? I mean, broadly speaking, parents and children have quite close ties, both upwards and downwards. Likewise, but likewise the spouse. But sometimes the spouse might be divorced, as I believe is the case with the current king's mother. It all depends on the circumstances of the particular case, how close to the current monarch they are. They might be completely estranged and have nothing to do with them at all.
I see that, my lord, and I am able to pray in my aid here the fact that we've got this recognition in Spanish law of the closeness of the ties. There are other features of the facts before the court below which might feed into this, and the court will have seen reference to the fact, for example, that my client continues to enjoy security paid for by the Spanish state. There's a risk, my lord, and it's a risk I'll run perhaps in a moment, but there's a risk in too much testing by analogy with, for example, the position of the households of this country or other countries. But to respond directly to my lord on that point, my lord will have seen reference in Apex to the case of Kilroy and Windsor, which was a case concerned with proceedings in the United States of America. And Prince Charles was sued in the American courts as a result of an individual being evicted overly forcefully, it was alleged, from a lecture he was given when the individual was protesting, I think, about Northern Ireland or something of that kind. The State Department got involved, and the State Department expressed the view that Prince Charles, as the heir to Her Majesty, was part of her household. Now, it's not clear from the law report where that concept came from, but what is clear is that the United Kingdom was making representations to United States authorities in relation to that case. And it may well be that the United Kingdom made protestations to the effect that Prince Charles was to be treated as a member of the household and was entitled to immunity. In the end...
But speaking to myself, I see no difficulty with that, because I don't know what age Prince Charles was at the time, but he was presumably an adult. All his adult life, he has assisted the monarch in the discharge of her functions. But that is not the case as regards your client.
No, my
since
lord.
2019.
That's absolutely right. But the phraseology, at least in the judgment, referring to the concept of household, treats it as flowing from his status as heir. It doesn't treat it as flowing from his discharge of royal function. My lord's absolutely right. He was an adult. This was a case decided in 1978. And he was, of course, discharging functions. But that's not how...
Indeed, I see Sir Arthur at the end of the passage quoted refers specifically to an heir to the throne of a monarchy being the kind of person who might be almost automatically part of the...
Yes. My point, my lord, is that, as I say, the State Department, whose views, as the court knows, carry particular weight in resolving issues of this kind in America, was expressing the view that he was a member of the household. But as I say, there's a certain risk in going too far into the weeds of what exactly one state or another does.
Very well.
Going back,
carry
then,
on.
my lord, to the judgment, and just to do justice, I hope, to Lord Justice Briggs's reasoning in it.
Well, remember, we have read it.
Yes, my lord.
So, and this is only a permission application, so I think you...
I'm grateful, my lord. Paragraph 35 is what we say is the key finding.
Yes.
Where Lord Justice Briggs said there was no interpretational basis for giving the phrase members of the family forming part of the household a wider meaning for heads of state than in relation to diplomats. And he gives a series of reasoning to that end. Relatively settled meaning, the wording of the 78 Act.
You don't...
I don't need to go through
No.
that. I'm grateful. Then at 40 to 41, this is important, I would respectfully submit, to the way we put our application. At 40 to 41, Lord Justice Briggs did consider the question of necessary modifications. And he held there that while it was theoretically possible for the proviso to lead to a different meaning of household, it was not a necessary modification to extend to the meaning of household along the lines contemplated by Sir Arthur at the end of his lecture relating to function, or the narrower basis contemplated by Mr. Justice Voss in his judgment at first instance. Now, we say, my lord, that it is at least arguable that this case can be distinguished from Apex Global in a material way which impacts upon the result. Or alternatively, as I said earlier, that the importance of the issue raised means that permission should be
we have the structure, yes.
Now, on the potential for distinguishing Apex, my lord, and drawing together, I hope, what I've been seeking to submit in the course of exchanges with the court, there are, we say, 7 points summarised in paragraphs 57 to 60 of our skeleton argument, supplementary skeleton argument, which we say show an arguable case for distinction. Firstly, the judge rightly accepted...
Well, I'm wondering whether you really need... The time is quite short.
It is, my lord.
Supplementary skeleton 56 to 63. Is that what you said?
57 to 60, I said, my lord.
57 to 60, I'm so sorry. Let's just look at those and see if that might be a shorter way of taking us through them. Yes, I have the supplementary certain.
and it's page 21. It starts that way.
Let's just let's just remind ourselves of those, and then if there's any ones you want to particularly elaborate, you can. Yes, I see. They're not therefore set out as 7 points in the way that
I'm
you
afraid they're not.
trailed.
But
Well, very well. Then just give us your 7 points in headline terms, but
Very
bearing
well.
in mind that we've read.
I'm very grateful. my lord. First point, the judge below rightly accepted that the assessment of household was a factual one.
Okay.
Secondly, the central finding of the Court of Appeal in Apex was twofold. First, that subject to the question of necessary modifications, the meaning of household was the same for diplomats as it was for heads of state. And secondly, the rationale for extending immunity to the household was to allow both the diplomat and the head of state to discharge their own functions. Thirdly, the reference in the Apex judgment to the concept of dependency should not be taken in isolation and divorced from the underlying purpose of the criterion, namely to allow that discharge of regal function not to be interfered with. Fourthly, back to the point I've been...
Sorry. Not to allow interference with the discharge of regal function.
Yes, my lord.
It's not, of course, only about monarchs, it's about any head of state.
Yes, my lord, yes. I'm using the term regal function,
Yes.
because both in Apex and in this case, that's
Yeah,
what
okay.
Fourthly, once that core purpose of the household extension is appreciated, we say, appreciate Lord Justice Jackson's reservations, contemplated reservations about that. We say it is at least arguable that where a royal house is defined as narrowly as this one, immunity can extend to the other 5 individuals on that basis.
On what basis? On the basis of membership of the royal? Is that right?
On the basis of inevitable interference with the regal
Oh, I
function.
see, right.
And a very obvious distinction, the point I've already made, between the Apex context of 5,000 and the Spanish context of 5. Fifthly, and this isn't a point I do wish to emphasise, if I may, such an approach would be entirely consistent with the travaux of the Vienna Convention on Diplomatic Relations. And as the court will know, the correct analytical approach to interpretation of an international instrument such as the Vienna Convention under the Vienna Convention on the Law of Treaties is ordinary meaning, and then in cases of doubt you can look at the travaux. Now the approach we contend for is entirely consistent with the travaux. Those travaux reveal 3 key features which support the applicant's case. First, the key to the concept involves a focus on close ties and special circumstances. This is 57.4 of our skeleton. Secondly, household is a concept, not a place. And so it's an error to fall into the trap of saying, do these people live under the same roof? And thirdly, in the travaux, it's clear that Spain, at least, had adopted the position that immunities and privileges should be extended to ascendants in the first degree, so embracing the position of my client. So that's the 5th point. The 6th point, I've mentioned it already, and I'll just give the references in the interest of time, but a recognition, at least, of the potential for proceedings relating to a particularly close relative to impact negatively on the dignity and functions of a serving sovereigns is well illustrated, we say, by the Duke of Edinburgh's will case, which we refer to at 57.6. And for the court's reference, it's tab 18, and the key passages are 704, 705, and 707. And seventhly, and this is, again, we say important because of the fact that it doesn't feature in the judge's judgment at all, even if apex could not be distinguished on the core meaning of household, as a matter of pure interpretation, as Lord Justice Briggs put it can be on the separate critical question as to whether on the particular facts of this case a modification is required. In other words, whether the proviso in section 20 is satisfied. And that aspect of the statutory regime must at least be common ground. Section 20 of the State Immunity Act does allow for application of the Vienna Convention in a modified manner when it applies to heads of state and their families, as opposed to diplomats and their families. It is not simply an exercise of transposition. And that's what section 21 of the Act itself tells us in terms, and as we've seen, Lord Justice Briggs accepted as much in his paragraphs 40 to 41. And here we say, tracking both the wording of the ILC Travo and the purpose of the extension as explained by the Court of Appeal in Apex, the modification would be to apply the immunity in such a way that it had regard to an individual's particularly close ties and special circumstances recognised in the relevant foreign law, which meant that to bring proceedings against that individual would undermine the dignity of the actual serving sovereign or the discharge of the actual serving sovereign.
You've slipped in the term dignity there. Previously, you've said all in terms of interference with the discharge of royal functions.
Well,
they're quite different things.
Well, I would respectfully submit they're not quite different things, my lord. They're intrinsically very closely connected, because if proceedings are permitted which are going to have an inevitably negative impact upon the dignity of a serving sovereign, that is bound as a matter of logic, we would submit, to impact upon the discharge of their functions, because the discharge of their functions is bound up with their high status and their dignity. That's why their position is so constitutionally important and matters so much. And that, we say, you get as a theme reflected in the Duke of Edinburgh case. Now, except, of course, it's an entirely different context. But the significance of dignity to discharge of regal function is, we say, very clear. And we say the two concepts are inextricable. And I emphasise, my lord, on this last point, as I have already, that on this question of necessary modifications, whether the proviso in section 21 applies at all, the judgment is completely silent.
You have said, Mr. Ottey, time is short. You've
Yes,
made
my lord.
that 4 times now.
I'm grateful, my lord. That was all I wanted to say on distinction.
Yeah.
If I'm wrong about distinction, and I, as I say, I hope I've at least made my position clear on a distinction that matters as well. Even if I'm wrong about all of that, and Apex, the judge was right at 63 to say Apex was unarguably binding against the applicant's case, then there is a sufficiently arguable case for revisiting Apex. And the court should at least allow for the possibility of that path.
What you really say is that well, Justice Briggs's refusal to accept Sir Arthur Watts's approach is arguably wrong, and the Supreme Court of the Chancellor can.
My lord, yes.
You don't need to say more than that.
I don't think you need to say more than that, my lord. There are additional points that I would submit.
That's the. If you don't proceed on that, you won't proceed on the additional points. Will you? I mean, the key point is here is, as you say, a very distinguished international lawyer, advancing you say, coherent theory of the basis for immunity, which is different from that adopted by the Court of Appeal in Apex, and that itself is something that the Supreme Court may wish to look at.
My Lord, yes. Could I just, the Court's been extraordinarily patient with me, I know. Could I just make two further points that I would emphasise in showing the potential for Apex to be revisited successfully? The first is, as the Court has seen from the judgment, the Court of Appeal treated the immigration directions issued some 30 years after the 1978 Act as providing a compelling insight into what the 1978 Act meant, and in that context referred to the one voice principle. Now that, we respectfully submit, is a novel and flawed approach to interpretation of a statute, and there is no scope for application of the one voice principle by reference to such materials, let alone when they are described as internal guidance only. And the second point, my Lord, is that there's no indication in the Court of Appeal's judgment that it had any regard to the close ties and special circumstances test suggested by the Traver, and which we submit to be critical and to provide the key test. And for all the reasons I've sought to articulate already, my Lords, if we are right on our definition of the Saratha test, essentially, factual question in every case, key criteria, does the evidence show close ties and special circumstances, then we can win on the facts too. So it's not an arid academic debate. So, my Lord, those are the submissions that I wish to emphasise on ground 3.
Right. So that's really the point you're making in your last sentence, is where the judge went wrong in para 64, apart from the particular points you say he didn't even mention, is in fact really wrapped up in the analysis you've just given us on
it is, my Lord.
On Apex. No, I see that. I mean, I think I know your answer to this, but I think it is the core difficulty, so I will just put it to you one more time. Granted that the defendant is a member of the core royal family as defined under Spanish law, but accepting also, as I think you do and must, that household is an autonomous concept, not a Spanish law concept, there must surely be it must surely be necessary to being a part of the monarch's household, either at least that you live with them, in which case you're part of the household in a domestic sense, that's perhaps most relevant in case diplomats' children type cases. But secondly, even if you don't live with them, that you perform part of the functions of the monarch, or are supportive to the functions of the monarch, which is a household in a rather different medieval history sense. If both of those are absent, what's left? Your answer, I think, is, well, you're still part of the household if anything that may be done to you may impact on the dignity of the monarch and therefore on the way in which he or she can discharge their functions. But that, in a sense, proves too much, doesn't it? It proves that every member of any member of the family would be immune, even if not in any other sense part of the household.
No, my Lord, to the last point we would respectfully submit. It's no part of our case that every member of a sovereign's family is part of their household. And it's no part of our case.
Okay, but is your definition effectively, it is any member of the sovereign's family whose involvement in as a defendant in litigation or prosecution under that would be capable of impacting on the dignity of the monarch himself or herself.
That would be one formulation, my lord.
I think it is your formulation, isn't it? Perhaps I haven't understood.
I think the way that I put it was that it was inevitable or entirely foreseeable that to pursue the closest members.
Two rather crucially different words.
Well,
inevitable and foreseeable are different.
All right. Well, let's settle on foreseeable, my lord. If it's foreseeable that, if it's objectively foreseeable that to allow pursuit of proceedings in a foreign court against individual X would impact upon the discharge of royal function by sovereign Y because of their special circumstances and close ties.
Well, but hang on, drop the special circumstances, close ties, but I want to see how it impacts on the discharge of the functions, because that's got to be your key concept, and it only does so, doesn't it, through the attack on their dignity or the implications for their dignity.
Well, no, my lord. It could be the entirely predictable, foreseeable impact upon their time and the distraction it would cause for them to know that individuals who were particularly close to them were being subjected to proceedings abroad. And one can't, we respectfully submit, simply dispense with close ties and special circumstances, where those are the words used by the ILC.
Okay, hang on a second. Would foreseeably have an impact on the discharge of the regal functions by reason of the close ties and special circumstances, whether by being prejudicial to the dignity of the monarch, or by distracting them or other from the performance of their functions, or perhaps impeding them in it. Something like that. Don't worry, I won't quote this as a finely formulated determination. I want to see how all these different phrases that you're throwing at us fit together. That is, I think, it.
My lord, yes. I mean, it may be helpful if we go just by way of example. It's slightly difficult to deal with this. I apologise if I'm not assisting the court sufficiently. It's slightly difficult to be as precise, perhaps, as would assist the court. But if we go by way of illustration as to how these concepts interrelate with each other to the Duke of Edinburgh's case, it's tab 18 of the authorities bundle, where the President of the Family Division is setting out a series of factors. First of all, cited to him and then approved by him in relation to the dignity of arson and the real constitutional importance of maintaining that dignity. And the court has that at tab 18.
I have which paragraph?
It's paragraph 43, first of all, where Mr. Crow's submissions are summarised. Again, paragraph 65 of those submissions. Paragraph 45, where again there's reference to the Attorney General's submissions. Paragraph 47.
Well, don't worry, we can look at this, and we indeed already have, but it's 45A is closest to the point we're making here, isn't it?
Yes, my lord. I just want to give your lordship the references for completeness, because those are submissions by the Attorney General. And then 55 and 57 are where his lordship essentially endorses
Adopts those, yes, right. Very well, we'll obviously have to think about that. Thank you. Yeah, it's fair enough that you look at that. You referred to it several times without making it clear. Yes. Well, I think that is on round 3, and it's effectively it on round 5 as well, isn't it?
Yes, my lord.
Yes. Thank you very much indeed. Yes, well, I think the sensible thing will be this, Mr. Lewis. If you address the section 14 points first, we will then go out and we will do one of two things. We will decide whether we need to hear Mr. Ottey in reply to you on those, and whether we need to hear you in reply on section 20 points. I think we'll be efficient to save us going out twice.
Well, I'm conscious of the times, and
Yes.
obviously your lordships have seen our written submissions on this, so I will be fairly brief. But so far as grounds 1, 2 and 4 are concerned, the appellant is intent on having the respondent pursue a case she is not advancing in order to improve his chances of being granted permission to appeal.
Well, you say that, but it depends by what you mean by what the case is. The case you have pleaded factually, forget for the moment whether it's fundamentally altered by the amendments, is that the King asks the head of the security services to take certain steps against the claimant. No private individual could get the head of the security services to do such a thing. Doesn't your pleading necessarily involve, however much you may want to disavow it, an allegation that the King is exercising his public functions, the correct phrase?
My lord, no, but for this reason, because the matters which he's asked his friend and confidant, so if my best friend also happens to be the head of MI6, and I ask him to portray a threat to my former intimate relationship I had with someone, it's not necessary that he does that in his capacity.
It's not about his capacity.
And
The capacity is your capacity in your example.
well,
I mean, there may be an overlap, I accept
but
that.
you could do it in either capacity.
But the question is not whether General Rondin, if I got his name right, has immunity. It's whether the King has immunity. What the King did is he asked General Rondin to do those things. So that's what we got to look at, the King's request.
Well, going back to, if I just develop it in this way,
Yes.
because logically the court should in fact consider ground 2 first, because if permission were not to be granted on ground 2,
Remind me which ground 2 is.
the ground 2 is the permission to amend the pleadings, because we say that was a case management decision, which there is no realistic chance of success on appeal. And therefore, one should evaluate ground 1 and ground 4 in the light of the amended particulars of claim.
Well,
on that point.
maybe, but I was starting with the original pleading just to test the point
But
intellectually. Because I'm happy now to look at the amendments you made, but I'm not at the moment satisfied they arguably change the position.
well, it does, we would say, to this extent. And of course, what we're dealing here, we must be dealing with, is functional immunity, or immunity ratione materiae, because he's no longer the head of state. And
Well, he was. Surely, have I not understood? These points only apply to the allegations pleaded against him while he was still head of state.
Yes, but that doesn't. But the only immunity which can subsist is immunity ratione materia, functional immunity. He cannot have absolutely in relation to grounds 1, 2, and 4 any personal immunity. He can only have functional immunity.
Oh, I see. Yes, right.
He is
yes.
a
Well, these phrases are less helpful to me than the phrases of the statute, which is the exercise of, what have it in my head, the exercise of his public. That is the point you're making, isn't it?
precisely right.
Yes.
So,
Sorry? In his public capacity.
in his public capacity, so it has to be rational, to use the
It
last
has to be in his public capacity.
which is a functional immunity or ratione materia.
Well, that's what you keep saying, but that
And
distracts from the actual words of the statute.
Well, that's the traditional way it's always put.
Well, I'm sorry if I'm not as
in
much of a
this way,
traditionalist.
because one has to understand how the immunity arises. It arises either because it was in only acts in his public capacity can be caught under section 14(1)(a). Only acts as his functions of head of state have immunity in relation to Article 39(2) of the Vienna Convention, because those are the only subsisting immunities. He has no personal immunity. Ground 3 gives him personal immunity because that is immunity ratione personae. That's what it says.
I got all that, but that was the objection I was putting to you.
Well, my lord, it's strange. My own friend hasn't dealt with this at all. Below, any reliance on functional immunity was completely disavowed. So that Sir Daniel said, we're not relying on functional immunity in relation to these acts, which are the pre-abdication acts. So because the defendant cannot rely on anything other than official acts carried out pre-abdication. Well, there is no immunity for that. So one has to look at both the character of the act and the context in which it was committed. So the act here, we say it's quintessentially a private act which will not be carried out in his public capacity.
How is it quintessentially a private act for the king to ask the head of the security services to carry out the pleaded steps against the claimant?
That's why I'd like to go to the, if your lordships will permit me.
Yes, please.
So we go to the amended particulars of claim. So if one assumes I could prevail on ground 2, which being case management position and decision we
Yeah, well, assume that for a moment, yeah.
We then go to the amended particulars of claim, which are tab 10 in the core bundle, begins at page 110.
Yes.
And if I could just pick up the amendments which eliminate, we say, any argument that the state is impleaded. Because it's only if the state is impleaded that state immunity could arise in this case. So the first one is at paragraph 4.
Well, hang on. That's just an unhelpful way of putting it. No, the Kingdom of Spain is not a defendant, clearly. No. But the former King of Spain is.
Yes,
and he's a person.
Yes, and he has no personal immunity once he's abdicated.
Quite. But at the time of the acts to which we attend, he hadn't abdicated, and he was doing these things on a, it might be said, on a straightforward reading of what is alleged against him in his public capacity. You say not, of course.
We say not.
But you can't say something that is contrary to the obvious facts and then expect that to be accepted. Oh, well,
Well, could I just test that with you, Lordship?
Okay.
Can I just test that? Because if we look at paragraph 4.
Paragraph 4.
Paragraph 4, page 111. That's the First Amendment. These are the paragraphs we're talking about. So we've deleted and those of the Spanish state. So
well, let's just pause there. The people in question were, as individuals, agents of the Spanish state. You're saying, yes, but he didn't use them in that capacity.
Well, for instance, in Monaco, there were a private security company called Aegis.
Yes, but they were laid on by General Roldan. according to the pleading.
If they're a private security company, that does not necessarily mean that the state of Spain is impleaded, because if I go out to a contractor, the fact that they have been engaged by myself or by the head of the Spanish intelligence does not necessarily mean that the state is impleaded. So if I could just, if you just bear with me. So if we take out those words, your Lordship sees there, where
Yes.
they've been taken out in red. And the other amendment, we go on, is at 13. The other amendment, which is an addition, General Roldan acted in his personal capacity on behalf of the defendant and not in any official capacity in respect of this and every allegation involving him in these amended particulars. And we've crossed out agents or contractors of the CNI.
Well, let's just pause there. I think this is probably just a nitpicking point, but it's not General Roldan's capacity that's in issue.
Oh, it is, my Lord, it's precisely an issue here, because this is why it's functional immunity. If
Well, okay, this is why I said it was a nitpicking point. The immunity has the phrase "in his public capacity" applies to the defendant, not to General Roldan. Your point, which I think I accept, so let's not spend time on it, is if the king, in his official capacity, asks the General Roldan to do something in his official capacity, to do something, he will be doing it in his official capacity. And conversely, if General Roldan isn't doing his official capacity, any request to the king to do so will not be in his official capacity.
But equally, the king can ask in his private capacity his friend General Roldan to do something, and that does not come even within the colour authority test. So, for instance, in the often cited example of the detective constable in America who assaults the Mexican consul.
Yes.
And one day, and then the next day, gets his badge out, arrests him, put him in the car and takes him to the jail, all with a completely improper motive. The first does not attract immunity, even though he was a state official. The second does, because he purported or did it ostensibly as a state official. So here, if I am, whether I'm the head of state or not, I could be any state official, if I get my friend to help me beat someone up, that is a private act, and that does not attribute that act to the state. So
I've got the distinction, but the point I'm putting to you, and that may well be you're right, but the point I'm putting to you is that where the head of state asks the head of the security service to do something that which is on the face of it, to use your phrase, ostensibly an exercise of his official capacity, you can't escape from that by saying, oh, well, I'm not relying on the fact he did it in his official capacity. I say he did it in a private capacity.
Well,
But if that, just by saying it, doesn't make it so, or doesn't make it arguably so.
But my Lord started with saying it's inevitable and it's a necessary consequence. We don't accept that.
No, I see you don't.
Because what one has to understand is why the whole rationale behind state immunity is that this court will not sit in judgment over the acts of a friendly foreign state. So that's why state immunity arises. If these are private acts, it is not sitting in judgment. and does have jurisdiction and can proceed. I mean, that's the rationale behind it.
Yes.
So here, the allegation, if the pleading said these could be private or public acts, but we're only alleging private acts.
Yeah.
And that is a feasible reading on the pleadings, therefore then state immunity is not engaged. If it was inevitable, I accept the position which my lords put to me, that it could be engaged. But in the circumstances here, and that's why it's important to look at the pleadings, because if we look at them, we then go to the next amendment, which is paragraph 16. And it was pleaded as CNI team. Well, the pleadings, it would now not be alleged that it was a CNI team. And at 19, which I think is the final amendment, is simply a clarification. One sees General Sands roll down, notwithstanding he was acting in a personal and not official capacity. So if one has to take the facts as pleaded as true, which we say is the right approach, and we are only pleading that on a specific basis, which isn't fanciful or simply a device to avoid state immunity, and it's a proper way in which it can be pleaded, then that does prevent the engagement of state immunity.
Yes, okay, I see exactly how you put it. It's been very clear. So the real test is whether the specification that's done as a private act is fanciful or...
Well, yes, because otherwise, every act the defendant did, and the approach my learned friend attempts to make, if I could sort of put it in this way, is if we adopt the Louis XIV's approach, l'estat et c'est moi. Everything I do is a state act. That just isn't right, because as one sees from the...
I think you're pushing an open door here.
So when one looks at the amended pleadings, so our preferred approach would be, we look at ground 2. Was the judge entitled to give that leave to amend in order to clarify what is being alleged? We say, undoubtedly yes. The court then looks at the amended pleadings, and the amended pleadings simply clarify that position. Allows room for a private act, and therefore there is no state immunity.
Speaking for myself, and maybe we have to hear Mr. Otti on this, if this was a viable amended pleading, I don't see much in the suggestion that it shouldn't have been done by the judge in the course of the hearing. Or even, I think, what's put against you is that there was never any formal application at all. You simply said in the course of oral submissions, if necessary, I'll amend, and then he picked you up on that and ordered that you did amend. That's how Mr. Otti says it went.
But of course, the judge says he wanted to clarify the way in which it was being...
He wanted, in a sense, to pin you down to your concession.
And we have pinned it down, and we have amended.
Well, speaking for myself, I don't think there's much wrong with that. If the pleading works, and that's what we've just been discussing, the amended pleading gets you home, then the only other point, I think, is the point about, based on his suggestion, well, the whole thing might change if further evidence comes out that shows that it's immune after all. And we see what you say about that in your skeleton.
Yes, that's ground 4.
Yes.
But that's only... One readily accepts you have to deal with these issues because they're jurisdictional. First, one has to deal with them finality. But that doesn't mean... Because in this case, the government of Spain have never put their head above the parapet. There is no assertion by the Kingdom of Spain whose immunity it would be, which would cloak these acts, that they are state immunity. And that we're confident there never will be.
But is this your position that, of course, in principle, it is highly desirable that jurisdiction issues are resolved at the very beginning of a hearing?
Yes.
Nevertheless, it may sometimes come up that you have to get some way into the hearing in order to reach a sensible adjudication about jurisdiction. One has occasionally seen cases of a completely different character where jurisdiction can only sensibly be decided at the trial. The judge hears a whole lot of evidence and at the end chucks the whole case out on jurisdiction. Not desirable, but in principle possible, because it may be impossible to reach a fair decision on jurisdiction earlier.
Precisely. And of course, it would be up to the defendant to put in some evidence. A point my Lord, or Justice Jackson pointed out, there is, for instance, on ground 3, there is simply no evidence at all. You can't make an inference. There was no dependency evidence put forward. However, if the King of Spain put in an affidavit saying, he is part of my household, that may change matters. One cannot finally rule it out at this stage, and that was all the judge was saying in his judgment, that matters may change.
Well, I don't think the two are alike. It would be perfectly easy for King of Spain to declare that the defendant was considered to be part of his household now, because the issue has arisen now, and now's the time to deal with it. It's not going to happen if that matter was to go on later. But what my Lord is asking you about is as it were, a fact-sensitive judgment as to whether somebody was acting in this or that, whether somebody was instructing in this or that capacity, whether somebody was acting in this or that capacity, which may not be, I suppose, apparent entirely from the pleadings. That's all.
Then if that arises, my Lord's absolutely right. That has to then be dealt with.
Yes.
Because
I mean, just to spell that out, what could happen in this case is it's allowed to go ahead on this basis, but it becomes clear at some point, possibly even at trial, that the king was in fact acting in an official capacity, and the judge says, "Well, now that's clear. It's clear I have no. Yes. It's clear he's immune."
But only for those pre-adjudication acts. The rest of the claim...
Yes, of course. No, I mean, I understand.
Ignore
in a sense, we're spending a lot of time on this point, but it's not, you say, I think the judge said it's not fatal to the case anyway.
It's not.
Because you've got enough of a course of conduct post-abdication.
Correct.
But still, it's on the pleading, and we've got to deal with it. The judge had to deal with it, so there we are.
But we say the clarification, that minor clarification, which one, when one looks at the amended particulars claim, one sees how minor it is. The learned friend has set up this Aunt Sally, say, well, the only inference is this is all done on behalf of the Spanish state. That is not our position, and that is not the way.
But it's certainly not your amended position, and it was ambiguous whether it was your original position, which is why you had to amend it. And effectively, I think, we'll hear what he says if we need to, but he may say it's tactical or fanciful. That's not really a realistic interpretation of the facts you allege. But you say no. The court can't possibly decide that it's fanciful, that they've done. He did this on a friendly basis, and neither of them in their official capacity. That's your position.
That's right.
Yeah.
And of course, this is only background. There are other arguments my friends putting up saying none of this can go in any event. It needs to be struck out because it's caught by a limitation period.
Yeah, but we're not
dealing with that. This is just a background passage, as it were.
Well, all the same, is before us. We've got to.
It is before you.
Well, I think you've had the kind of time appropriate for these sorts of submissions. And speaking for myself, you've dealt with the points that don't mean successfully dealt, but you've addressed the points that concern me. Unless my Lord has any questions, I think the sensible thing would be for us to go out and see who we want to hear from on what.
Thank you. Should we pop outside?
Horses through all the tests.
Well, we'll see.
Okay, I already did this, by the way. Vote twice.
Thank you. Well, we don't need to hear from either counsel, from which you will infer that we propose to refuse permission on ground 3 and allow it on grounds 1, 2 and 4, and we, as to ground 5, we do not think this is a case in which, notwithstanding our views about the reasonable prospect of success, there is another compelling reason for the appeal to succeed. So proceed. Now, we will not give our reasons straight away. Just, we will circulate them in writing in due course. I don't have, unless you hear to the contrary, we won't adopt a formal hand-down procedure and drafts beforehand. It's not that sort of case. You'll simply get the reasons. They will have to be formally handed down, but you won't get all the bells and whistles on either side. But that leaves the question of any consequentials, which it is sensible to deal with now, unless, which I don't think is the case, you can't deal with them without reasons. The appeal that will proceed on grounds 1, 2 and 4 clearly should be heard soon. It can't, I'm afraid, be heard before the vacation, but I should be surprised, though I give no promises, if it can't be heard early in the new term. I don't think either party will be suggesting it needs to be vacation business. The points are actually quite narrow on 1, 2 and 4. My feeling, I haven't discussed this with my lord, but he will intervene if he takes a different view without embarrassment, is that it's frankly not a full day case, but a half day, maybe a little short. If I were to give it an estimate of 3 hours, the practical consequence of that is I suspect you will get a full day, but it will keep the parties from being too long-winded. So. I said he would disagree. If he'd say a day.
So,
I was being too nuanced. But I think I'm perfectly prepared to express the view that should be comfortably dealt with in a day. The ordinary directions will, I think, apply. I think, given the intervention of the vacation, the ordinary directions for timetable and so on won't need any modification, because you're not going to be heard on October the 1st. But I trust the parties to be sensible about that. If, which I haven't worked out, there has to be some abridgment of the ordinary timetables in order for everyone to be ready for whatever date is fixed in the new term. I would hope you could agree such an abridgment. What else?
An extension of the stay of Mr. Justice Nicklin's directions, my Lord, for the substantive hearing. Your Lordship stayed them pending this application. And
Yes. Now, is that, well, first, is that opposed?
I wouldn't have thought so, Bob. Can I just check that I don't misspeak on this and with those instructing me?
Yes.
But I mean, it seems sensible that we need to deal with, we're going to have to deal with this appeal so we know where we stand. Because part of the directions for Mr. Justice Nicklin were to strike out these paragraphs for different reasons, either because they were committed abroad or because they...
Well, I think if it's the joint position that the stay should continue, no doubt on the understanding that it would be heard early in the new term, the court's not going to, I think, disagree. I think it might be, if there had going to been a much longer delay, we might have wanted to think about whether there were some things that could be got on in the meantime, because of course part of the appeal that survives doesn't affect the viability of the proceedings as a whole. But having said that, I can see it may be rather complicated to work out which bits you need to deal with and which you don't until the appeal has been resolved. Take instructions, why not?
Could we say that we'll try and agree that as long as we can get on an early part of next term. If we can't, liberty to apply in writing just to see where we get to.
I think that's sensible. I imagine both parties will be consulting the list office quite early. I'll communicate my views about an early date. But you will quite soon discover who that when that date will be, and then yes, liberty to apply for the stay will be continued, subject to a liberty to apply when it becomes clear when the hearing will be. Sorry for a bit of working out, but
my Lord, could I just return to the question of time estimate? I appreciate your
Yes.
Lordship's views. It would respectfully be our submission that 1.5 days would be more appropriate. We will need to go into Jones, we'll need to go into Circus, we'll need to go into Alatia, and the questions of attribution and the proper and principled approach to amendments in this context is significant, my Lord. There is a further judgment pending from His Honour Judge Pelling in the Commercial Court in relation to Qatari state agents or alleged state agents, which addresses these issues which Mr. Luckhurst and I argued in April. That took 4 days in the Commercial Court. Now, admittedly, there were more parties, but I would respectfully submit that it may be very compressed if it's as little as a day.
there's no dispute as to Jones and Circus, is there?
Well,
the question is an interpretation of what is pleaded here.
Well, I don't know, my Lord. I don't know. That is certainly a critical question, what is pleaded and what is permissible in terms of departure from that initial pleading. But it is also critical, we say, to nail down exactly what the test is. Is it colour of authority? Is it a broader, only a broader test of a private citizen could do this? And it's not entirely clear either from the judge's judgment or from the learned friend's skeleton argument where he lands on those issues. if everything we've said about the right test is accepted and all one's dealing with is the proper principled approach to amendments, I can see that a day would be sufficient. But that's not how we read the interplay between the parties at the moment, my lord, I'm afraid.
I'm afraid you haven't persuaded us, Mr. Artie.
Discharge my duty of
Bad.
Well, you have, and I mean, we all know that shorter submissions are very often more winning, so it's,
We'll take that
that's
on
the
board.
challenge. Could I make one suggestion, if my lord would allow, which is simply that the papers for this hearing have been very well prepared, if I may say so, and it should be possible, I think, for you with your teams readily to be able to strip out
Yes, my lord.
what is there that now no longer interests this court. And just to renumber, I wouldn't have thought, now that you've got your arguments very clearly defined, it's going to be anything other than a blue pencil exercise. So we're not going to be starting on a restatement of any cases. It's simply just removing the parts that grounds
Ground 3 and
5 don't relate to.
Yes. Well, that
And the
must be
authorities
right.
bundled
Indeed, you'd be
here.
wrong in principle, I think, to be raising new points. But certainly because of the confusion we had about the skeletons before, I don't think my lord is suggesting that it's satisfactory just to have the existing skeletons cut and pasted a bit. I think a bit of work will have to be done.
We'll put in if it's acceptable to the court, what I was going to propose, we will put in a fresh skeleton, dispensing with the other two completely, filleting out everything
And
that's
the
irrelevant,
authorities bundled.
complying with the page limit, and dealing only with 1, 2 and 4.
I think the important thing that I had in mind was that nothing that either of you is going to read is something that you won't have read before.
No, that's certainly,
So there's not
that's
going to
certainly
be,
the
not going to
case.
be any new stuff,
There won't be new arguments.
because you've now pleaded it below and here.
Yes, ma'am.
Well, thank you very much. We will obviously intend and expect to get the reasons out very quickly.
Thank you, ma'am.
But it won't literally be tomorrow or the next day because I'm doing a 2-day appeal. And my lord is similarly engaged. But you won't have to wait very long.
Thank you very much.
Thank you both for your succinct and clear submissions.